Google revealed yesterday it received more than 42,000 requests for user data from law enforcement worldwide last year. That is an all-time high. With us now, senior correspondent John Miller, a former FBI assistant director. John, good morning.
Good morning.
So this is the 7th report. It's up. What does it tell us?
Well, it tells us that computers and electronic communications are more and more involved in the commissions of crime, but it also tells us that law enforcement is getting more adept at figuring out how to use these things to do everything from mapping a suspect's social network to try to determine if they can find the criminal network in there, as well as determining if something's happening.
Should we be worried about this because they're using this as kind of warrantless searches?
Okay, so there's a lot of press out there about this, and you know the headlines all say government warrantless snooping of your email is up. Yeah. Now these are very charged terms, so let's do a quick civics lesson on how this is supposed to work in real life. When they talk about subpoenas, when you look at the numbers, you see the big numbers are in subpoenas, and then the smaller numbers are in court orders and other things. So when you're talking about subpoenas, that is them saying, who does this email account belong to? What's the name and address on the other side of this? When you talk about court orders, that's, all right, now we've determined we have probable cause. We want to go to a judge and say we want to read some of these emails. And then when you talk about, you know, Title III orders and things like that, that's when they're saying we want to watch this email in real time, like a wiretap.
Yeah, but if you're an individual and your Google searches and your Google emails, there is plenty of evidence that you don't necessarily need a subpoena, law enforcement doesn't, in order to look at that. And that has people worried about the government snooping. Unfair?
Well, the government can't go prying in. First of all, we got to use a stepladder approach here, too, which is, if you've ever talked to an FBI or DEA agent and about their caseload and how many cases they're carrying at once, the idea that they have time to go snooping through people's email over curiosity is absurd. But when you talk about what it takes to get that, a subpoena is for transactional data, subscriber data. If you want content, what's being said in those emails, you pretty much have to go to a judge and get a court order.
Okay, so you are suggesting that no law enforcement official with access to emails is always going to exercise perfect discretion and integrity.
I would say that's definitely not true.
Yeah.
And I would say
we are all human.
Right. No, but I mean, I think what you have here,
curiosity gets the cat.
I think what you have here is they make more mistakes than they have things through malice. When the FBI got the national security letters power from the Patriot Act, the Inspector General did an audit and they found out that there were widespread abuses of the NSLs. And what you saw was a very small percentage of cases where, because of the complexity of the process to actually fill these things out and get them, that they made a lot of mistakes. You also found that they weren't getting information, even through the NSLs they messed up, that they weren't otherwise entitled to. And you'll probably see the same here, some mistakes.
John Miller, thank you.
If I have access to your emails, I'm never stopping. I just want you to know.
We will definitely read those.
It'd be very boring, Charlie.
Yeah. Charlie's would be boring, I'm sure, though, to read his emails.
I read all his when I was in the FBI.
Exactly.
All right, everybody.